Hey everyone, it's Rob Ryder again on Saturday, April 13th, 2013. And look at some stuff that has to do with mainly the summary proceedings used for crimes. And around that, how other actions are started. And, uh, and then the question of, is a notary a justice of the peace? So, got an hour? See if I can do it. Okay, so Blackstone's Book 4, Chapter 20. Oh, can't start there. Got to start here. Blackstone's Book 3, Chapter 18. The pursuit of remedies by action, and first of the original writ. And an action is something that's done in law. Actions are law. Bills of complaint, petitions, things like that are done in equity. So actions at law. For it was a maxim introduced by the Normans that there should be no proceeding in common pleas before the king's justices without his original writ, the king's original writ, because they held it unfit that those justices, being the only substitutes of the crown, should take cognizance of anything but that was thus expressly referred to their judgment. So if it didn't come from the king for them to judge it, they don't judge it in the court of common pleas. However, in small actions below the value of 40 shillings, and again I think that's where this $20 comes up, because of our Constitution, 40 shillings in Blackstone's time, which are brought into court bearing a county court, no royal writ is necessary. Alright, so if you're going to a court baron's court, or the county court, you don't need original writ. The foundation of such suits continues to be, as in the times of the Saxons, not by original writ, but by a plaint. And on a plaint, you have a plaintiff. That is, by a private memorial tendered in open court to the judge. So whatever is actually happening that means anything in that court is a private memorial tendered in open court to the judge. Everything else is a show. If you didn't give it to him in open court, it didn't happen. Wherein the party injured sets forth his cause of action, and the judge is bound of common right to administer justice therein without any special mandate from the king. Now, tendered in open court. I mean, you just talk it? Do you give it to him? I don't know. But it's for something that has a value of less than 40 shillings. Or there is an original writ under the Great Seal from the Court of Chancery. One of those great things you can ask, is there an original writ under the Great Seal of the Court of Chancery in this case? If not, it has a value less than 40 shillings. Why are you trying to take my house? But we don't have to go to court for that stuff. We want to take them to court. And so, we've tried to put on our own civil actions, and I know people have tried for years and years and years and years and years and years and years to try to figure out how to get over criminal action. And well, it looks like you put a complaint under oath and you give it to the trier of the fact through a justice of the peace. And that justice of the peace could be a notary who's really just witnessing your paperwork. But instead of doing a notary presentment like you would send it to an attorney, now you're going to do a notary presentment and send it to the judge's law clerk or to the judge. And as you'll see, they're supposed to have two books, one for civil and one for criminal. Or they can have two books. Two dockets. Okay, so this is a paraphrase out of this chapter 20, book 4, summary convictions, talking about crimes against the public. Another branch of summary proceedings is that before justices of the peace, in order to inflict diverse petty pecuniary mulcts and corporal penalties denounced by act of Parliament for their disorderly offenses, such as common swearing, drunkenness, vagrantness, idleness, and vast variety of others, for which I must refer the student to the justice books formerly cited, and which used to be formally punished by the verdict of a jury in court leet. Now, the funny thing about a jury, well, I guess it ain't so funny. Juries do verdicts. Yes, that is correct. This change in the administration of justice has, however, had some mischievous effects. The almost entire disuse and contempt of the court leet and the sheriff's torn, the king's ancient courts of common law, formerly much revered and respected, whatever they look like, the burdensome increase of business of a justice of the peace, which discourages so many gentlemen of rank and charter or character from acting in the commission. So a justice of the peace is a commission. A notary has a commission. For the apprehension that the duty of their office would take up so much of that time, which they are unwilling to spare for the necessary concerns of their family, the improvements of their understandings, and the engagements of other services of the public. So because of these summary proceedings, I guess the business of the justice of the peace really picked up. Though if all gentlemen of fortune had it both in their power and inclinations to act in this capacity, the business of justice of the peace would be more divided and fall the less heavy upon individuals, which would remove that in the present scarcity of magistrates is really an objection so formidable, that the country is greatly obliged to any gentleman of figure who will undertake to perform that duty, which in consequence of his rank in life he owes more peculiarly to his country. All right, so it's good to be a justice of the peace. A notary is a justice of the peace. However, this backwardness to act as magistrates arising greatly from this increased summary jurisdiction is a product of a third mischief, which is that this trust, when slighted by gentlemen, falls of course into the hands of those who are not so, but the mere tools of office. Now, in Michigan, in the compiled laws, when it defines a magistrate, it does say that a magistrate is a judge of a district court, lowercase district court, or the municipal court. And if you go to the district court website, which is the traffic court, in there, that district court, there's also a probation office, which to me is probate. Probation, probate. Nevertheless, when you look on the website, it says that is where all criminal proceedings start, is there. So a magistrate in Michigan, by definition, when it comes to criminal stuff, is one of these judges. But he's sitting there as the trier of the fact. And I know this from last year when I tried to put some criminal complaints in, and I had sent 3 to this one particular district court. I happened to end up there in a traffic court one day because I'd been picked up for not paying $25 on a, what the hell was it? Child support. I had for $25 I had a warrant out for me. Anyways, as I'm sitting there in court and she's going through what I'm there for, she stops and she wags her finger and somebody hands her some papers, and by God, it was the papers I had sent to the court I hadn't heard anything on. After she had said that, I really had to study these 3 times, I really had to study these, and then said, it's not that you're not correct, I'm just not inclined to issue any warrants. To which I said, well, then you're allowing color of law to be used against a living man, and that's fraud. To which she said, well, you could appeal my decision to the circuit court. But by this time, because I don't know, I walked into an uppercase district court, the only circuit court I knew was uppercase also, but I knew in the statutes they use these lowercase formulas. It's like, where are these freaking courts? Anyways, the next week she sent me a response to my complaints, and basically on all 3 of them it said I had given no just cause. And it took a while to digest what that meant, but over time I said, okay, well, I didn't put them under oath, number one. And I didn't really provide any evidence. I just made a complaint. But I really think it was just because I didn't put it under oath. Now, out of all this, the important thing is when she said, it's not that you're not correct, I'm just not inclined to issue any warrants, right? She's the trier of the fact who's going to issue the warrants. And this is a district court judge. At traffic court, landlord, tenant, that kind of stuff. She's the trier of the fact. And from some of the stuff that I did videos on earlier this week, it looks like you're supposed to take yours to the Justice of the Peace, who's acting as the public's prosecutor, and they take it to the trier of the fact to have a probable cause hearing. And if there's probable cause, then they will issue a subpoena for the defendant to answer the charge. Bad enough to just issue the warrant to answer the charge. So who is this other Justice of the Peace, right? If that judge, magistrate sitting there in this court is the trier of the fact, then the question is, who's the Justice of the Peace that you take it to prior to it going to them to be the public's prosecutor? And I think it's as easy as being the notary, who's already witnessing your affidavit. It's your complaint. All you want them to do is get it before the judge. So if they were descended as a notary presentment from their office as a notary and docketed in their book, having a book for criminal stuff, how can that hurt anything? How can anybody go to jail for that? You know, you don't send this shit to somebody's attorney. You send it to the judge. Make it a criminal complaint. Back to the story. And then the extensive power of the Justice of the Peace, which is even in the hands of men of honor, is highly formidable. Right? The power of a Justice of the Peace is highly formidable. Will be prostituted to mean and scandalous purposes to the law, ends of selfish ambition, avarice, and personal resentment. Do you think we're suffering from that now? It's because nobody's filling the role of Justice of the Peace. Well, which one are they talking about? They're not talking about the trier of the fact here. They're talking about the public prosecutor being the notary, sending the stuff to the court. That's one option. But again, it's your complaint. You're doing the complaint. You're putting it under oath. You're providing the evidence. It's just, I don't think we send it directly to the judge. It has to go through an intermediary, and it could just as easily be their clerk, which is the other option. You know, because we'll see here in a bit, the clerk took on a lot of power when they, and by the clerk I mean the court administrator. They took over the administration of the court. They're the law expert. The judge is just the trier of the fact. But since we don't do this, the extensive power of the Justice of the Peace, which even in the hands of men of honor is highly formidable, is prostituted to mean and scandalous purposes, like mirrors sending something with a notary seal on it from one state to another, right? Saying it's a verified frickin' verification of debt. It's got a notary seal on it. One thing to remember in that case, anytime a notary sends something from one state to another, it has to have a certificate of authority with it. More on that later. And from these ill consequences we may collect the prudent foresight of our ancient lawgivers, who suffered neither the property nor the punishment of subject to be determined by the opinion of one or two men. And we may also observe the necessity of not deviating any farther from our ancient constitution by ordaining new penalties to be inflicted upon summary convictions. So, what can we do? The process of these summary convictions, it must be owned, is extremely speedy. Though the courts of common law have thrown in one check upon them by making it necessary to summon the party accused before he is condemned. This is now held to be an indispensable requisite. Though the justice has long struggled the point, forgetting the rule of natural reason expressed by Seneca, he who accuses another, however just it is unjust unless the accused defends himself. A rule to which all municipal laws that are founded on these principles of justice have strictly conformed. The Roman law requiring a citation, at the least, and our own common law never suffering any fact to be tried till it has previously compelled an appearance by the party concerned. So what's the first thing they're going to do? Is they're going to summon you to court. And that's why in a traffic case, when they give you a citation, which is really just a promise to appear, and you don't appear, the clerk of the court is going to file a criminal complaint, take an oath to it, and get a warrant against you for failure to appear. After this summons, the magistrate in summary proceedings may go on to examine one or more witnesses, as the statute may require, upon oath, and then make his conviction of the offender in writing, upon which he usually issues his warrant, either to apprehend the offender. In the case of corporal punishment, it is to be inflicted upon him, or else to levy the penalty incurred by distress and sales of his goods. This is, in general, the method of summary proceedings before a justice of the peace. Before a justice or justice of the peace. But for particulars, we must have recourse to the several statutes, I think they're the penal codes, which create the offense or inflict the punishment, and which is usually chalk out the method to which the offenders are to be convicted. Otherwise, they fall, of course, under the general rule and can only be convicted by indictment or information at common law. So either you point out the penal codes, or there has to be an indictment or an information at common law. On this indictment, if it was a true indictment, would have the signature of the grand jury foreman on it, and the information would have somebody that excuse me, has put something under oath. So an information to me is the same as the affidavit. To this end, of summary proceedings may also be properly referred the method immemorially used by the superior courts of justice of punishing contempts by attachment and the subsequent proceedings thereon. The contempts that are thus punished are either direct, which openly insult or resist the powers of the court, or the persons, the judges who preside over them, or else are consequential, which plainly tend to create a universal disregard for their authority. So what they're talking about is when you get your complaint in, they're going to send a subpoena to the defendant, commanding them to appear. If they don't appear, they committed contempt. And now the court can charge them with a contempt, just like the clerk did against you in a traffic case. The principal instances of either sort that have been usually punished by attachment are chiefly the following kinds: those committed by inferior judges and magistrates by acting unjustly, oppressively, irregularly, or administering the portions of justice which are entrusted to their distribution, or by disobeying the king's writs issuing from the superior courts, by proceeding in a matter in a cause after it was put to a stop or removed by writ of prohibition, certoria, error, yada yada yada. So the first one is if you want to put a complaint against a judge or a magistrate from an inferior court for giving a willfully fraudulent judgment based on the perjury of a witness, or it's the perjury of the witness, one of the two, but it's at least one of those two. So I'm going to say it's a willfully false judgment in this case. Any corrupt or inquisitive practices of subordinate judges are contempts of the superintending authority, whose duty it is to keep them within the bounds of justice. So since the Supreme Court has superintending authority over the other courts, that's who you would put your complaint into, the Supreme Court. Now, is it the one that says Michigan Supreme Court? I don't know. I think it's the appeals court. I think the appeals court judges, when they get together, make up the lowercase superior court or Supreme Court here in Michigan. How do you find that? Well, what if you don't know? Well, you send them both one. Those committed by sheriffs, bailiffs, jailers, and other officers of the court. Oh, officers of the court abusing the process of law. In other words, abusing the process of law, simulating a legal process, or deceiving the parties by any act of oppression, extortion, collusion, behavior. Right? You can put one in for that. Those committed by attorneys and solicitors who are also officers of the respective courts, and they're always considered in court, by gross instances of fraud and corruption, injustice to their clients, or other dishonest practice. For the malpractice of the officers reflects some dishonor on their employers, and if frequent or unpunished, creates among the people a disgust against courts themselves. There you go. I mean, how prophetic, right? We're living it right now. Right? You want to send their ass back to the fleet? Go put in a criminal complaint. They brought fraud on the court. They're simulating a legal process. They don't have a complaint under oath. They don't have anything under oath. Those committed by jurymen. The jury commits fraud, right? So there's another one by giving a false verdict. Refusing to be sworn or to give any verdict, eating or drinking without leave of court. See, I bet you these grand juries that get together, they probably don't take an oath. I don't know what they're doing, but they're giving false or erroneous verdict. Those committed by witnesses, by making default when summoned, refusing to be sworn or examined, or prevaricating in their evidence when sworn. And so this is the one that we're really using. If you're not in a foreclosure, but you think you own your house, well, you don't have the legal title. And if you were to look at your title insurance, it says the title company insured your title in fee simple. But you never got it in fee simple because the frickin' closing never finished. And so you don't have your legal title, and they never defended it in fee simple. So they're on the hook. You send them a claim about it. If they don't answer, or they give anything but, yeah, we're going to take care of that right away, you can go and file a complaint through a justice of the peace to the trier of the fact, who will subpoena the insurance company in based on the evidence. And what's the evidence? Well, I have a policy here that says they had a duty to defend my title in fee simple. I don't need to go at the bank, nobody else, man. I just go to the title company. It was their duty to get me my title in fee simple, and I don't have it. And for all the other reasons we've already talked about, as far as, mortgages. Only one part. You're the only one that signed. There is no recorded lien. You'll think of some more. I go back and watch the video, see what I said. So those committed by parties to any suit or proceeding before the court. So if you're already in court, disobedience to any rule or order, such as getting a default judgment against them for not filing their complaint, right? Now you got the default judgment. They're guilty of a crime, man. They didn't file their complaint. Go put in a criminal complaint based on the default judgment. Or by non-observance of awards duly made by arbitrators or umpires. Arbitrators and umpires. I've heard of both of them before. They have binding arbitration, which is really what I think you're in when you're in this fake court with no court seals. It's just a form of binding arbitration. And when they get the final judgment, right, then the court can put their seal on it. They will enforce the judgment of binding arbitration. And apparently of umpires also. Those committed by any person under any degree of peer, and even by peers themselves when erroneous and accompanied with violence. Okay. By disobeying or treating with disrespect the king's writs, which is a subpoena. That is an original writ under the Great Seal from the Court of Chancery. It's a we command them to appear and answer the charge. Or the rules of process of court, such as not putting in a frickin' complaint under oath, not providing a proper summons, not providing proper notice. By perverting such writ or process to the purpose of private malice, extortion, or injustice. I think that's what they're doing. By printing false accounts. So the process of attachment, which is what they're going to use on them in this subpoena process, right? For these and the like contempts must necessarily be as ancient as the laws themselves, for laws without a competent authority to secure their administration from disobedience and contempt would be vain and nugatory. And so the whole thing with the subpoena, it goes back to one of the chancellors, Catholic bishop, came up with this thing called a subpoena, because they couldn't overturn the law judgments, even though it had been done in fraud, because law only cares who has legal title. So then what they had to do was come up with a way to compel whoever got the judgment to come to their court and answer for their lack of conscience. And it was with a subpoena. A power, therefore, in the Supreme Court of Justice to express such contempts by an immediate attachment of an offender results from the first principles of judicial establishments and must be an inseparable attendant upon the superior tribunal. Okay, so you can, I'm going to tell you about the history of it. If a contempt be committed in the face of a court, the offender may be instantly apprehended and imprisoned. Bingo, if it happens in court. If you point out in court, for the record, I believe this to be a, what's the word? Simulating a legal process. I don't believe there's a complaint been filed. I believe the prosecutor's committing perjury. If there's no complaint filed, then the complainant witness is committing perjury because there's no complainant to be a witness for. It happened in court. They could arrest him right there. Arrest that man. But in matters that arise at a distance, and of which the court cannot have so perfect a knowledge unless by the confession of the party or the testimony of others, if the judge upon affidavit sees sufficient ground to suspect that contempt has been committed. So, if you give the judge an affidavit with probable cause, and then he's going to send a subpoena, and they don't answer the subpoena, well, they're going to have a writ of attachment put against him. They either has been committed, they either make a rule or on the suspected party to show cause, and why an attachment should not issue against them. Or in very flagrant instances of contempt, the attachment issues in first instance, as it also does if no sufficient cause is shown to discharge, and thereupon the court confirms and makes absolute the original rule. Right? They're going to have to come to court, or they're going to have to come before the court and try to settle out of court. This process of attachment is merely intended to bring the party into court. It's just merely to get you there. We're going to subpoena your ass. If you don't show up, we're going to arrest you. Just trying to get you in here. And when there, he must either stand committed or put in bail in order to answer upon oath to such interrogatories as shall be administered to him for the better information of the court with respect to the circumstances of the contempt. These interrogatories are in the nature of a charge or accusation. This is your complaint, and must, by the course of court, be exhibited within the first 4 days. And if any of the interrogatories is improper, the defendant may refuse to answer it and move the court to have it struck out. If the party can clear himself upon oath, he is discharged, but if perjured, he may be prosecuted for perjury. If he confesses the contempt, the court will proceed to correct him by fine or imprisonment or both, and sometimes by corporal or infamous punishment. The exact things that we think we're going through in court in their fictional world is what's going to happen in the real to them. If he contempt be of such nature that when the fact is once acknowledged, the court can receive no further information by interrogatories, then it is already possessed of. The defendant may be admitted to make such simple acknowledgement and receive his judgment without answering to the interrogatories. Okay, so he doesn't need to answer the complaint. He can just say he's guilty. He can admit to it by simple acknowledgement. Under oath, because all this is under oath. But if he willfully and obstinately refuses to answer or answers in an evasive manner, he is then clearly guilty of a high and repeated contempt to be punished at the discretion of the court. This is where you got a choice: verdict of a jury or judicial battle. It cannot have escaped the attention of the reader that this method of making the defendant answer upon oath to a criminal charge is not agreeable to the genius of common law in any other instance. Apparently, there's nothing else in common law where you need to answer under oath, except to a criminal charge. And it seems indeed to have been derived from the courts of King's Bench and Common Pleas through the medium of the courts of equity, being the courts of Chancery. And to defy the court of Chancery shall bring the thunderous wrath of the Vatican upon you. Well, so this was all set up through the court of Chancery. For the whole process of the courts of equity, Chancery, is the several stages of cause, and finally to enforce their decrees. Decrees are given in Chancery. Judgments are given in courts of law, was till in introduction of sesquiritins in the nature or process of contempt, acting only in personam, on the person, and not in rem, not on the property. So on the subpoena will be their name in proper case, not uppercase. Anytime you see your name in uppercase in a court case, it's an in rem proceeding because that's your frickin' property. That's your landed estate. And the best you can be in a civil case is its attorney. When we go to equity, which we're doing by putting in a criminal complaint, it will be in personam against the person. So now the person I'm against is the corporation. It is a legal person. But it has officers that control it. You know, I'm going to let the court decide who's at fault. Captain always goes down with the ship. And thereafter the party in contempt has answered the interrogatory, such as his answer to be contradicted, disproved by affidavits of the adverse party. I don't remember him saying in there, but they don't get to have an attorney for this. They answer. They may get to have counsel, but they still have to answer the questions under oath. And in this regard, a singular mode of trial thus admitted is one particular instance I shall only for the present observe, that as the process by attachment in general appears to be extremely ancient, and has since the Restoration been confirmed by an express act of Parliament, so the method of examining the delinquent himself upon oath with regard to the contempt alleged is at least of as high of antiquity, and by long and immemorial usage is now become the law of the land. The law of the land is a summary hearing in a criminal matter, summary hearing by a writ of attachment for contempt of court, and the contempt would be not to answer the complaint. Beautiful. Now, hang on just a second here. So here's this court case, 241 U.S. 1, J.D. Compton versus State of Alabama in 1909. By an affidavit, proper in form and substantially sufficient in its statements of fact, made before a notary public of Fulton County, Georgia, Compton, the plaintiff in error, was charged with having committed the offense of being a common cheat and swindler. So somebody had taken a complaint and said, hey, this guy's a common thief and cheat and swindler, before a notary. The solicitor of the criminal court of Atlanta officially notified the governor. So who's the solicitor of the criminal court? Right? I think that the solicitor of the criminal court is the court administrator, or at least works for the court administrator. Accused had been so charged and had fled to Alabama, and the requisition of the governor of Alabama asked for extradition of Compton. To that end, he might be brought back to Georgia to be tried according to the law for the offenses charged. The governor of Georgia thereupon made requisition of the governor of Alabama, who, having received the requisition, issued his, I like how they use the word requisition, they use so many military terms in this stuff, issued his warrant, another military term, for the arrest of Compton, if to be found in Alabama, and his delivery into the custody of agent of Georgia. Having been arrested under the warrant by the sheriff, the accused sued out a writ of habeas corpus before the judge, city courts of Montgomery, Alabama, and sought to discharge from custody upon the ground that he was illegally restrained of his liberty. The return by the sheriff to the writ justified the detention of Compton under the requisition of governor of Georgia and the warrant of arrest issued by the governor of Alabama. Upon hearing of the case before the judge of the Montgomery City Court, the accused demurred to the return, and the demur having been overruled, he was ordered into custody of the agent of Georgia for extradition pursuant to law. From that order, Compton prosecuted an appeal to the Supreme Court of Alabama, and that court affirmed the order of the Montgomery City Court. It contended that the affidavit upon which Governor of Georgia based his requisition, although certified by him to be authentic, that's the certificate of authority, was not in compliance with the revised statutes of the United States. Okay, so apparently that's what the court affirmed the order of the Montgomery City Court. It contended that the affidavit upon which the governor of Georgia based his requisition, although certified by him to be authentic, was not in compliance with the revised statutes of the United States, that the proceedings in Georgia were not sufficient to authorize the governor of Alabama to issue his warrant of arrest, and that the proceedings on the hearing on the petition for habeas corpus did not show that they had been an indictment against Compton or such an affidavit before a magistrate of Georgia charging the accused with a crime as required by the statutes of the United States of America. So what's the question? The question really is a notary a magistrate? Because this revised statute of the United States says it has to be before a magistrate. In our judgment, the only material question not substantially covered by the former decision of this court is that raised by the objection that the affidavit in Georgia, under the seal of a notary, on which the governor of the state based his requisition, was made before a notary public and not before a magistrate, as required by the revised statutes of the United States enacted in the execution of the constitutional provisions relating to fugitives from justice. This specific objection was raised by the assignment of errors for the Supreme Court of the state, but that court did not seem to have regard it as sufficient gravity to be specifically noticed in its opinion. But as the objection is covered by the assignment of errors for this court, and as it asserts a right under the laws of the United States, we deem it proper to meet and dispose of it. So the Supreme Court's going to make the decision. Is a notary public a magistrate? The proceedings against Compton were had under subsection 5278 revised statutes 1901, page 3597, as follows. Whenever the executive authority of any state or territory demands any person as a fugitive from justice of the executive authority of any state or territory to which the person has fled, and produces a copy of an indictment found or an affidavit made before a magistrate of any state or territory charging the person demanded with having committed treason, felony, or other crime, any crime, certified as authentic, certificate of authority, by the governor or chief magistrate of the state or territory from whence the person so charged has fled. Notary seal of the certificate of authority. It shall be the duty of the executive authority of the state and territory to which such person has fled to cause him to be arrested and secured, and to make cause notice of the arrest to be given to the executive authority making such demand, or to the agent of such authority appointed to receive fugitive and cause fugitive to be delivered to the such agents when he shall appear. Okay, so this is going from one state to the other. If you're going from one state to the other, notary paperwork must have certificate of authority that will be under the court seal of the court of record of your county, for lack of a better term. And on there, a lot of times they say that this gives it full faith and credit. It can be used in any court in the world. If no such agent appears within 6 months from the time of the arrest, the prisoner may be discharged. Okay. All right. So, undoubtedly, the statute does not make it the duty of the governor to issue a warrant for arrest of an alleged fugitive from justice unless the executive of the demanding state produces to him either a copy of an indictment against the accused in the demanding state or an affidavit before a magistrate of such state, charging the fugitive with commission of a crime in the state making the demand. And so the governor didn't seem to have a problem doing it when it was under the notary. Right? Notary public started this, had the certificate authority with it. And boom, they issued the warrant. So the notary must have sent it to the governor of the state. And the governor of the state then looked at it, yep, got it right, put his certificate on and asked for a warrant to be issued. But an affidavit before a magistrate. And a magistrate is a justice of the peace, and a justice of the peace is a notary. It is, we think, equally clear that the executive of the state in which the fugitive is at the time may decline to honor the requisition of the governor of the demanding state if the latter fails to furnish a copy of an indictment against the accused or an affidavit before the magistrate. So obviously, Governor 2 doesn't need to accept it from Governor 1 unless it is proper, which would be an indictment or an affidavit before a magistrate. But has the executive of the state upon whom the demand is made for the arrest and the extradition of the fugitive the power to issue the warrant of arrest for a crime committed in another state unless he is furnished with a copy of the required indictment or affidavit? We are of the opinion that he has not. So this is good to understand. If you're in one state now and they say they want to extradite you from another state or to another state, what you want to know is the indictment been done properly, or do they have an affidavit? Do they have a complaint under oath? Because if not, they can't extradite you. He has no power so far as any authority in respect to fugitives from justice has been conferred upon him by the statutes of the United States. He does not have any power unless he has an indictment or an affidavit. And so what we need to know is those things need to be under oath and need to be proper. If they're not, he can't issue the warrant. The statute, we think, it makes it essential to the right to arrest the alleged fugitive under warrant of the executive of the state where the alleged fugitive is found, that such executive be furnished before issuing his warrant with a copy of an indictment or affidavit before a magistrate in the demanding state. So, okay, got to have those two things. An affidavit before a magistrate. Supreme Court's not disagreeing. It is therefore material under this interpretation to inquire whether the affidavit made the basis, in this case, of requisition by the governor of Georgia, and which is certified to be authentic, certificate of authentication, was such an affidavit as the revised statutes of the United States required, this is in the absence of an indictment, to be produced to the governor of Alabama as a basis of a warrant for arrest that he might issue. The record shows that the affidavit, a copy of which accompanied the requisition of the governor of Georgia, was made, as we have already said before, a notary public. Was that sufficient under subsection 5278 of the revised statutes requiring an affidavit to be made before a magistrate? That is, before one who could properly be deemed a magistrate within the meaning of law of the state under whose authority he acts as a notary public, and in which his duties are discharged. In a general sense, a magistrate is a public civil officer possessing such power, legislative, executive, or judicial, as the government appointing him may ordain. In a narrower sense, a magistrate is regarded as perhaps commonly regarded as an inferior judicial officer, such as a justice of the peace. But the appellation of magistrate is not confined to justices of the peace and other persons, whatever that is, who exercise general judicial powers, but it includes others whose duties are strictly executive. In this case here, the question was whether an alderman of Philadelphia, now an alderman would be like, I guess, my county commissioner who took over from my township supervisor, since we don't seem to have townships anymore. The Michigan Constitution is unconstitutional, because it has a section in there that says this section of the Michigan Constitution violates the federal Constitution and has been deemed unconstitutional. Article 7, Section 7. The question was whether the alderman of Philadelphia, who was invested by law with the power and authority of a justice of the peace, was not to be deemed in the strictest sense a magistrate, within the meaning of a statute relating to the acknowledgement of deeds before justice of the peace or magistrate. So the interesting thing back to the alderman, they're saying the alderman, whatever that ends up being, is a justice of the peace. They have all the powers and authority of justice of the peace, but not in the strictest sense to be a magistrate, within the meaning of the statute relating to acknowledgments of deeds before justices of the peace or magistrate. Mr. Justice Story said that the alderman was to be deemed a magistrate within the statute referring to, said he, I know of no other definition of the term magistrate than that he is a person clothed in the power of a public civil officer. Clothed in a sackcloth, just a low-level public officer. Could a notary public be deemed a magistrate in Georgia? If so, then subsection 5278 of the revised statutes was satisfied, for the statute must be held to mean that a person may be regarded as a magistrate before whom the required affidavit can be made, if he is so regarded under law of the state where the alleged crime has been committed. Upon looking into the Code of Georgia, we find that the provision is made for the appointment of notary publics by judges of the superior courts on the recommendations of grand juries of several counties. Their term of office is 4 years, and they are commissioned by a governor and are ex officio justices of the peace and shall be removable on condition of malpractice of office. Okay, so it isn't like these notaries went before a judge. They applied to get the frickin' job, right? Applied for the card. And all this stuff is just seals going on paperwork in the background. But at the end of the day, when you look at a notary's commission, like here, it's, they got a commission from the county. And you can go to the county clerk and get the certificate of authority for them. Other places, their commission comes directly from the state, and you have to go to the state to get their certificate of authority. So they say, and it should be easier than what it is, but if you're not sending it out of your state anyways, it doesn't matter. You can just use your local notary. Her seal's good anywhere in the state. His or hers, it's good anywhere in the state. And all we want them to do is, instead of doing a notary presentment to an attorney or a bank, to send one to the judge and put it in a docket book. They are designated as commissioned notary publics. They have a commission. If you didn't know it, you're in the military. Actually, you're in the office of magistracy. One of the two sons of oil. Divine law says there will be a civil government. Right? Men are meant to live in civil societies. And these justices of the peace, from the ones we've seen before, at the magistrate level now, sitting in these courts, right, they rule the county. And they're just waiting for us to come in the right door and do it right, because it's not that you're not correct. She wasn't inclined to issue any warrants, and the only reason was I didn't give any frickin' just cause. I didn't put it under oath. And it is therefore provided that justices And notary public who are ex officio justices of the peace shall keep separate dockets of all civil and criminal causes disposed of by them. You got to have two docket books, civil and criminal, as a notary. And by God, you're ex officio justice of the peace. And lay their dockets before the grand juries of their respective counties on the first day of each term of the Superior Court for inspection. So I don't know anything about being a notary, right? But if you're laying your docket book before somebody, call them and ask them. Right? But I'm sure if you really read your notary handbook, you're going to see that what needs to be done isn't asking that much. You're just going to mail it. You're going to take the person's oath and their information and mail it. Do a notary presentment to the judge. Mail it to them. Probably mail it to the clerk. In view of these provisions of the Code of Georgia, we hold that the notary public before whom an affidavit in that state was made may be regarded as a magistrate within the meaning of 5278 revised statutes of the United States. All that to get to that, Supreme Court says, in view of the provisions of the Code of Georgia, we hold that the notary public before whom the affidavit in the state and that state was made may be regarded as a magistrate. And then this is just a few of the things off of something I did on a video earlier, a couple days ago. The system under pressure. In the third quarter of the 16th century, the rule of the JPs began to be questioned. It was alleged that many of them neglected their duties and were incapable of performing them. In other words, Elizabeth is Lord Keeper. Her Majesty may be driven, clean contrary to her most gracious nature and inclination, to appoint and assign private men for profit and gain to seek her penal laws to be executed. At the same time, was acknowledged that there were many consciences. These, however, were said to be overburdened and unable to meet the increased demands of their office. If you ask an attorney if he's a notary, they are. Right? All these offices are notaries. And all notaries are therefore justices of the peace. And if the right people aren't using the office, as it said in Blackstone, it's going to be used against you. And that's all that's happening. And so for this, for gain's sake, right? So some people that are notaries do it to make a profit, right? They're going to charge you to do the paperwork. Well, that's okay. As long as they're fulfilling the office, they can do that. But a lot of them do it for free. The key is it needs to go into a separate docket book for criminal matters, is how I read it. The most controversial ordinance affecting JPs was the Act of 1652, empowering them to perform marriages and making all other forms of ceremony illegal. When this exclusive right was repealed, it became necessary to regularize the position of those already married by JPs by providing the Act of Charles II. Such marriages were to be held valid. So I was incorrect before. I thought that only JPs could do marriages, but apparently they changed this at some time later. There was one point where it was their exclusive right. All other forms were illegal. But I bet you still JPs that do it. Everybody that does a marriage is probably still a JP. JPs relieved of their administrative duties. Between 1829 and 1888, JPs were relieved of some of their major administrative duties, with the exception of liquor licensing, which was thought widely that they would soon be relieved of their judicial duties also. The historian wrote, the JP is cheap, he is pure, he is capable, but he is doomed. He is to be sacrificed to the theory on the altar of the spirit of the age. The reason I put that in there is, if you remember, they had legislative, administrative, and judicial functions, right? And they're going to give their administrative functions up. Well, who would they give their functions up to but the court administrator? Then, since he wrote these words, the judicial responsibilities of the JP have increased almost annually. Yeah, they're going to go away? No, they got bigger and bigger. The Justice of the Peace Act of 1968. The act provided for the gradual reduction of the age of retirement of the bench from 75 to 70 and confirmed the position of clerk as legal advisor to justice. The fact that 98% of all cases which come before the criminal courts of England and Wales are disposed of by JPs with no required legal qualification continues to surprise many people. The justification is based largely on the relationship which has developed over the years and in 1968 received statutory authority between JPs and their clerks. The JPs bearing sole responsibility for finding of fact and on credibility of witnesses, the clerk advising them on the law and the extent of their powers. So, it comes down to who is this clerk? Is it the clerk of the court? The circuit court? I don't think so. I think it's the court administrators who run that particular court. So like the district court has a court administrator, the circuit court has one. They each have one. And that person acts as a legal advisor to the justice of the peace, sitting as the trier of the fact, because they're going to advise them on the law. So that being the case, if you were to send your complaint, you can't find a notary that will send it for you. You can still have them put it under oath for you. You would send it to the clerk, and they would look at it, see if it's lawful. And if they find probable cause, because they are a justice of the peace, because they are a notary, because they are an attorney, they're all those things, then they would have a probable cause hearing with their judge, and he would issue the subpoena. And if the subpoena isn't answered, then he will issue the arrest warrant. And they don't necessarily have 21 days on these. You know, people that have been in like landlord-tenant things, 5-7 days, it can be in court. Right? As soon as the complaint goes in, because justice will be swift. And that was the reason for doing these summary judgments that Blackstone talks about. So anyways, I'm going to say that a justice of the peace is a notary, and a notary is a justice of the peace. And if you go to them and they put the seal on it, they could easily put it in an envelope and mail it to the judge for you. But it could just as easily, I guess, go directly to the court administrator. And we'll find out. We got 2 or 3 of them out late this week, and we'll just see if there is swift justice. And stay tuned for more. Have a great weekend.